I can make money by sending emails? I like this theory. Brent, I like this theory. How do I sign up? All right. We have a child placement. We're going to start with that. And then we got a few other clips that you're going to like today. Oh my God, Bill is here. Hey, Bill. I love that you're doing Fleischer again during the day. Thank you. Thank you for doing that for us. We appreciate that. We do. And when I say thank you for doing Fleischer again during the day, what we really mean to say from the bottom of our hearts is thank you, Emily. Thank you, Emily. We adore you. I wish there was a word I could say that's bigger than we adore you. But the feelings that we have for Emily are eternal. We love her. But child placement. Let's do that.
The delinquency matter.
Oh, okay.
Oh my
She's
gosh,
welcome.
Bobby. Bobby, that's so weird you said that because, okay, when I got divorced, I was married 19 years with 3 kids. And it was just, I mean, even though I was married, I was already a solo parent. Okay? So when I got divorced, you know, the people around were like, hey, you have to start going out. You know, you have to start going out. So I started going to the American Legion every Friday. And the American Legion is like a members only club, but not like that, don't worry. I mean, the membership for the year was like $30. And every Friday they would have a live band come in. And I would get myself a pitcher of beer for $6. For me, that was mine. That wasn't shared. And okay, Brad, he did have a very, very fine allergy that I could have used. I didn't because my name's not Aaron Patterson. But so I met another group of friends at the Legion. Okay, I met one of them last night at my job. I was working. And she's like, man, you really look like Kathy. I said, yeah. And then I remembered who she was. She says, I want to tell you something. She goes, I used to go on Friday nights, and I had no idea how to get up there and dance with the rest of the girls, and I really wanted to. Because that's sort of how it went. Like, the girls would all go up and dance, and then every once in a while, one of the guys would come up with us. But it was mostly just the girls. And she said, I just really want to thank you. She goes, I had so much fun because you went there and you had me come up and dance with you. And she said, if it weren't for you, like, I didn't know how to go do that. And it was such a good time. It was a good moment last night for me. It really was. But she said that. She said, thank you for teaching me how to dance with you guys on. Hi, Jamie. I'm sorry, I'll get back to the court video now. I can't help talking sometimes.
I wasn't sure if she was here yet,
Yes,
so.
her and her fiance and her daughter.
Can you take that?
Over there, sit in that second chair.
What is that traffic
Miss
court on the
Adams.
door? You have the door open, so I see a sign on the door.
Oh,
A traffic court sign. We'll take that down. Okay. Oh, you don't have to do it like this moment.
Swimming pool, maybe. Swimming. It works the whole
Okay, good
body.
afternoon. We're going to start on the delinquency matter. I am going to call, this is in the interest of Emery Newberry. I've got, I think, 3 different case numbers, so I'm going to run through them. I've got 2600014, which was the terroristic threats case, which we handled back on January the 15th, at which time Emery admitted to that 1 count of terroristic threats, was adjudicated delinquent, and we did a partial disposition, but withheld the final disposition until today's date. Then I've got 25. Actually, this one is 26-00011, which was the delinquency petition, which alleged that Benry Newberry was a delinquent child by one count, which was simple assault, that alleged that on and about January 3rd, 2026 in Hall County, Georgia, that Benry committed the offense of simple assault when he committed an act which placed Tasha Thompson, his mother, in reasonable apprehension of immediately receiving a violent injury, to wit, he stood up and took an aggressive stance in violation of OCGA section 16-5-20D. And then I have 25-00985, which was a delinquency petition filed on January 7th, 2026, which alleged that Benry was a delinquent child by one count, which was simple assault, Family Violence Act, which alleged that on and about December 31st, 2025 in Hall County, Georgia, that Benry committed the offense of simple assault when he committed an act which placed Tasha Thompson, his mother, in reasonable apprehension of immediately receiving a violent injury, to wit, he became aggressive with her and acted in a manner to suggest he may become violent in violation of OCGA section 16-5-20D. Those two cases, when we were here on January the 15th, Benry entered a denial, and so that matter was set down for an adjudication or trial today. I've been handed out one piece of paper, so I just want to, for the record, we have Benry who's here today, and Benry, you're being represented by Ms. Atkinson. As always, if you have questions or don't understand something we're talking about, just raise your hand, let me know, and I'll stop and give you time to talk to Ms. Atkinson, okay? Did you have enough time to talk to Ms. Atkinson before you came in, or would you like some more time right now?
I'm good.
You're good? Okay. We've got Ms. Green, Ms. Diaz from the District Attorney's Office. Ms. Hobson is at the center table from Juvenile Probation. We've got Attorney Kimberly Beatty, who is on Zoom, who is the attorney guardian ad litem for Benry. And then we have representatives from the Department of Family and Children's Services. We've got Ms. Courtney, who's here for the dependency case. And
in Georgia, the cases that I get, so Judge Manning and Judge McBurney in Georgia, they have their own courtrooms that they go to every day, okay? But a lot of these other judges in these small counties that I get, they go from county to county and sort of share courtrooms. We see her in other courtrooms quite a bit, not doing child placement hearings, doing much worse. Like, she gets some pretty violent people. I wish I could remember which courtroom. It's the Georgia courtroom where the judge sits on the left, and we get to see trials in there quite a bit. We saw, what's that attorney's name? It's Shapiro. The defense attorney Shapiro, who keeps asking for mistrials when he loses. Anyway, she is really, really good when she gets a murder or kidnapping, or we see her in some really good trials. We didn't see her last time she was here. We saw the other judge with the, was it Walter or whatever, special needs, 17 years old. He was just about to age out of placement, and you know, they found a way to keep him until he was 21, as long as he signed the papers. Remember that? It was great. They did such a great job with him. But that was a different judge. So now we have her, who we see do major cases, travel to this courtroom. This is Hall County, Georgia. And she's doing this boy.
we have Benry's mom, sister, fiance, and Ms. Dodson, who are all here for the dependency case, but are in here as interested parties, I guess. I've been handed one piece of paper, which is in relation to 25-00985, which appears to be an admission to ungovernable. So are we resolving both cases with this one document?
We are. The state's going to dismiss the other case, and he will be admitting to ungovernable in 25-00985.
Okay, so 26-00011 is going to be dismissed
That's correct.
by the state. Okay. And then 25-00985 will be resolved with an admission to ungovernable as a Chen's offense?
Yes.
Okay. Okay. Ben Marine, I know last time you were here, we reviewed your rights document, and I've got it here in the file, but you know that you are here today scheduled for a trial in this matter. So the state of Georgia was prepared today to have a trial, to present witnesses and evidence. Ms. Atkinson was here ready to defend you in that trial. And that by entering an admission today, you're going to give up that right to a trial. So we're never going to have a trial. We're just going to talk about consequences. And it sounds like the attorneys have kind of negotiated and reduced some things down to a Chin's offense. But you understand that you're giving up that right to a trial. So we're not going to have a trial. We're just going to talk about consequences. And I see you nod your head, and I know that means yes, but everything is recorded through the microphone. So you just have to say yes or no out loud, okay?
Yes, ma'am.
Okay, so you understand that by giving up that trial, we're not going to have one, and we're just going to talk about consequences?
Yes, ma'am.
Okay. So, Ben Marie, I've been handed a document. This one's titled Admission Denial, and the word admission has been circled. And this one states, I, Ben Marie Newberry, understand the nature of the charges against me and hereby admit the charges contained in the attached petition, specifically ungovernable. And it appears as if you've signed it, Ms. Atkinson has signed it. And I'm going to guess that this was Mr. Amfalami's signature as the parent for defects on this form. Is that your signature?
Yes, Judge.
Okay. Ben Marie, did you want to come in today and resolve these cases by entering an admission to ungovernable?
Yes, ma'am.
Okay. Has anybody put any pressure on you or made you sign this document or tell me you want to admit to that charge when you really didn't do it or you don't want to sign this paper?
No, ma'am.
Has anybody promised you anything in exchange for signing this document or entering an admission? And are you under the influence of any drugs, alcohol, medication, anything that could affect your ability to think clearly today?
I wish.
You've got your attorney sitting next to you. You have a lot of adults in the courtroom here who are interested and who can give you good advice. But what matters to me is that this has to be your decision and your decision alone. So, Ben Marie, is it your decision to enter an admission to ungovernable?
Yes, ma'am.
Okay. Ms. Atkinson, do you believe that?
I don't know how old he is, but how can he's a minor. So how can he give his permission for this?
Ben Marie is making this admission freely, knowingly, and voluntarily.
Where's his guardian ad litem? Shouldn't she be the one?
I will accept the admission and find that it's made knowingly, freely, and voluntarily. Are we in a position to handle disposition now?
We are, Your Honor.
Okay. Ms. Green, on behalf of the state.
I'm not sure quite what the cleanest way is to handle this. We did a partial disposition in a delinquent case previously. I don't know that Ben Marie needs to be on Chin's probation in the traditional sense with Chin's reviews, given that there is a dependency case that is pending. So the only addition I would make to the partial disposition and the requirements already put in place would be that he participate in individual counseling. And then I'm sure that his attorneys explained that the requirements of his previous probation will still remain in effect. So that is the only additional requirement that the state would request.
And so with the Chins, that does trigger us having those periodic reviews that the code requires. If you're not looking for those, would it be the, I guess, proposal that essentially the court, I can make a...
My thought would be that we could amend the partial disposition in the delinquent case to add individual counseling and find that Chin's probation is not necessary based upon him being on delinquent
And that's
probation.
what I was trying to think of the correct word that's in the statute, essentially kind of advice and counsel.
Yes.
Don't do it again on the Chin's offense, and then we'll use, and it was set for our final disposition on the third case number, which I think is 26-00014, and make the partial disposition final, adding in individual counseling.
I don't know what. I see. We don't watch enough of these child placement hearings for us to really be familiar with everything. I don't know what it means for him today. He is admitting to being ungovernable. So I don't. I hear that he had, that he is hurting his mom or, is too aggressive to be at home. And that's why he's in placement. But what does being ungovernable mean if that's what he admits? What happens to him? What are the consequences? I'm sure they'll tell us. I'll just shut up.
Yes, Judge. I was
I'm
just
not
going to
gonna-
essentially
Okay.
propose that we not really put a disposition in place on the ungovernable count and just finalize the partial disposition.
Okay. Ms. Hobson, do you have anything in addition to add on that?
I do want to add on there that he do get enrolled in school. I don't know if it's more appropriate during the dependency part, but for delinquency, this youth is currently not in school, and that is a huge concern. So I would ask that he get enrolled in school immediately.
Okay, so y'all give me just a minute because I've got a few stacks of paper here. I'm going to make sure I keep them all straight.
Oh, why drunken? That's the part I liked. Because the guardian ad litem's not here, or because, well, okay. I don't know if this, okay, I think they added that in now because he's taking a plea deal. Today was supposed to be trial, so they were probably going to already ask for that if they won the trial. I don't, maybe that's why they just added that in now. I don't know, but that's the part I like. The boy needs counseling. Poor mom. Can you imagine being a mom and you have to have your kid locked up? You have to do it. I don't know how old he is. I don't know if he's 17. The other one was 17. I can't tell by looking at him how old he is.
Ms. Green, would the state just prepare the dismissal on the 011 case?
That was my intention,
Okay,
was
then I'm
to
just-
submit that.
I'm just going to fold that document up and not create more paperwork. Okay.
Yeah, I think the mom is definitely right there. I think she has the purple Crocs on, but I'm not sure. Nan, I'm sorry to be showing you Crocs like this. With no warning or nothing. Just don't look. Here, I can put my face over them. Is that better?
Okay. So for the 26-00011 case, that case, the court will sign off on a dismissal once submitted by Ms. Green on behalf of the state. For 25-00985, the court is finding that Bemery came to court today and admitted to one count of ungovernable. That is a Chen's offense. I've just indicated that advice and counsel given, no additional supervision, treatment, or rehabilitation required. So Bemery, know that the things you did are not appropriate, okay? Understand that if you have any further ungovernable threats of violence, which I'll talk about in your other case, but because I'm telling you I gave you advice and counsel, don't do it again, okay? For 26-00014, I'm entering this final dispositional order and finding that Bemery came to court back on January the 15th, 2026, where he admitted to terroristic threats. That is a delinquent offense. He will be placed on probation, fees waived. I've just indicated the same requirements as before, which were an ankle monitor if requested by the Department of Family and Children's Services, to comply with DFAC services and not disrupt placement, take medication as prescribed, no violent behavior or threats of violence towards anyone, and then I've just added in the check mark for individual counseling, okay? Any questions? I'm going to pass these two orders down, and we'll get those signed, and then once those have been signed, we can make copies, and then we'll transition into the dependency case.
I want to join your Croc cult. Sign me up. Right now we took care of one ungovernable charge. Now we have another one to deal with. Shame. Shame, Bren. Shame. Don't you know they hurt our Nan?
Okay, so if you were just here for the delinquency case, you are excused and free to go. You're also welcome to remain should you wish. I'm just going to ask you to switch seats. If then we can move to the middle table. Yes, and then Ms. Thompson, if you want to come up to the SPAR table here.
Now we'll see a guardian ad litem. Who's that standing in the left with the black sweatshirt?
Okay, and as we get situated, I'll go ahead and style the case. We are here. This is case number 23-00532. We're here today on the dependency case for Bemery Newberry after this court. Well, we all know historically we've been through a lot with Bemery in the last couple months, but essentially we are here today for a disposition hearing after Bemery re-entered into the custody of the Department of Family and Children's Services. We had a hearing, I think, on the 23rd of January, at which time everyone was given an opportunity to be heard on this court's emergency modification of disposition, at which time the court continued Bemery in the temporary custody of the Department of Family and Children's Services and scheduled today's date essentially as a disposition hearing to consider any new proposed case plan with Bemery's re-entry into foster care. So we are here today, and present with us in the courtroom, we have Ms. Gravitt representing the Department of Family and Children's Services. We have Mr. Aaron Falami and Ms. Sam Filippo here on behalf of the department. We have Bemery as present, being represented by his attorney, Ms. Courtney. We have attorney Kimberly Beatty, who is present as attorney guardian ad litem, appearing via Zoom. We've got the mother, Ms. Tasha Thompson, who is present, being represented by her attorney, Ms. Dodson. And then I'm going to guess this is Bemery's sister, and then the significant other in the home with Ms. Thompson. And then we have Ms. Hobson, who's here from juvenile probation. And we have another person in the courtroom that I don't know. Intern with?
The sheriff's office.
The sheriff's office, okay. Okay. The court, in advance of today's hearing on, looks like February the 13th, did receive a proposed case plan from the Department of Family and Children's Services, which proposes a permanency plan of, a type of non-reunification, but the plan being guardianship. That's the only document that I have, so I'm going to turn it over to Ms. Gravitt.
Thank you, Judge. And I'll note, just for a preliminary procedural matter, I believe our office did submit a summons for the non-reunification case plan we proposed. I'm double checking my file. I'm not sure if the court issued.
Probably not, because I probably held it thinking we could talk about it today. So certainly with the department proposing a non-reunification case plan, Ms. Dodson, you would have the opportunity to review that, and then we would typically set a hearing within 30 days of the department proposing that. We did have our disposition hearing today. I did not know what the mother's position was on that today. Certainly we can schedule another hearing, or if you'd like to kind of take care of it today, that's certainly your client's rights.
I think Mom's position was to take care of it today,
Okay.
Judge. If I could just have just a moment.
Sure.
I did receive the proposed non-reunification case plan on Friday. If I could just have just a moment to
Absolutely.
regroup with Mom.
Sure.
And where is Bemery currently placed?
He's currently placed at Safe Haven in Columbus, Georgia.
And is that a group home setting?
Yes, it is.
How is he doing in the current placement?
He's doing very well. The reports I've gotten is been very helpful at the placement, super responsive to redirections, all around just doing very well.
And what are recent referrals made for Benry?
I recently made a new referral for psychological for Benry, and I also made a psychosexual assessments also for Benry.
And have those evaluations been completed, or are they pending?
I believe they're still pending.
And what services is he engaged in?
Right now, I do believe he's engaged in individual therapy and medication management.
And are those services provided through his placement?
Yes.
And what is the status of his schooling?
As at the 11th of February, I was able to get the school records from Salem Middle School, so I sent that over to placements. Placement informed me that I sent them to the school, so it's being worked on, I believe.
Oh, man. Oh. He got his records from Salem Middle School. This tall boy, who's probably taller than the lawyer sitting beside him, is in middle school. So, for those of you who are not in the United States, we have grade school, middle school, high school. High school starts at 9th grade, which is what? How old are you at high school? 18, 17, 16, 15? 14 and 15, I think, is 9th grade. So that means he is younger than that. Oof. Oof.
At the moment.
So they sent his previous records to his new school to get him enrolled?
Yes.
That might be wrong, because think about it. Incorrigible. Exactly, Eileen. He might be older than that because he might have failed a couple years. We don't know. I don't know if his grades might be spectacular. I'm not saying his grades are bad, but they could be. He could have skipped some years. I don't know.
And has Benry been provided with ILP opportunities, or will he be provided with those?
It will be provided with those.
No, the boy walked from the
And,
one table to the other table, and we saw him stand up and walk over. So that's how I said the tall boy.
Is there any timeline to your knowledge of him getting re-enrolled in school?
Not to my knowledge. What I was informed is, I guess in the Columbus area, it takes a minute for school enrollment to take place for kids in that area.
And as to the ILP opportunities, how will those be provided?
They will be sent to placements.
And what is the department's proposed case plan today?
Non-reunification guardianship.
And has the department spoken with the mother, Ms. Thompson, as to her position as to the child returning to her home?
Yes.
And what, as relate to you, is her position?
She does not want Benry to reunify at this time.
And what are the department's efforts toward guardianship?
So we'll look back into Ms. Tasha's dad. I've tried to contact him a number of times last week. I've been unsuccessful with that, but he's the only person we're looking at this time.
Are there have any other relatives come forward as a guardianship or relative placement option at this time?
No.
And does the department, from having this case previously, have a copy of Benry's medical records and birth certificate?
Yes.
Stay off your knees then.
And at Benry's new placement, has he been able to receive medical and dental care yet?
Yes, he has.
Any concerns?
None that was related to me.
And has Benry been able to have telephone communication with his mother at his placement?
Yes. They almost talk every day in the
I
mornings.
can see that. If you put the crock down before you kneel inside the crock, that would be pretty comfortable.
One moment, please. And what is your understanding? Does Bimri wish to be adopted at this time?
No.
And does the department intend to file a petition for termination of parental rights?
Not at this time.
They left the door open a crack for mom, guys. A crack.
And as to the putative father in this case, has he reached out to the department at all
No.
throughout? How long have you been on this case?
Over a year now, and yeah, over a year now.
And at any point during your time on this case, has the father reached out to express an interest in engaging with the department or case plan?
No.
Is the department aware of the putative father's whereabouts?
No.
I have no further questions at this time. Thank you.
Ms. Courtney, any questions for Mr. Aaron Falami?
Yes, just a couple. When it comes to visitation with the mother, you said it was every morning,
Phone calls.
phone calls. Is it
Yes.
any sort of Zoom calls or just over the phone?
I believe it's just over the phone. I'm not sure if they do FaceTime or anything like that.
Okay. Do you know if Bimri is allowed to have in-person visitation with the mother regarding the delinquency cases?
That would be something I have to discuss with leadership.
Okay. No further questions.
Ms. Dodson, any questions for Mr. Aaron Falami?
Just briefly, Judge. Mr. Aaron Falami, you guys met, the department met with mom, was it last week or the week before last?
It was the 5th.
It was what?
The 5th of February.
5th of February?
Yes.
Okay. And during that meeting, you discussed with mom non-reunification and case plan goals and everything like that?
That's correct.
Okay. In the case plan that the department has submitted today, a lot of the referrals for Bimri, they've been completed, correct? Like the assessments and evaluations?
That is correct, but I also made new referrals for him also because
Okay.
like the psychological was way back in 2023, I believe. So I made a
Okay.
new referral for that and a new psychosexual also.
Okay, so we've updated some more referrals for Bimri, is that correct?
That is correct.
Okay. And then Tasha's dad, the department has, the new case plan is non-reunification and guardianship. Is the grandfather, the maternal grandfather, is he the only guardianship that we're looking at this point?
That's correct.
Okay. And just for clarification, he was the former guardian that was just recently terminated?
That is correct.
Right, okay. Can you just clarify for a few things for me? Your testimony was that mom did not want to reunify with Bimri. In fact, she's worried about her safety as well as her daughter's safety. Is that correct?
That is correct.
Okay. Do you have any reason to believe she doesn't love Bimri?
No.
She doesn't. She would like to have him back in the home, just not possible at this point?
Yes.
Okay. And then position as to TPR, I just want to get some clarification for you. The question that was asked of you is the department at this time is not looking at terminating parental rights. Is that because you do not believe that it is in Bimri's best interest to terminate mom's parental rights?
Yes.
Okay. And they have phone calls every morning, to your knowledge. Any negative reports from placement, Bimri, or mother about those phone calls?
No.
Okay. And then you're going to staff the idea of having in-person visits with mom and Bimri with upper leadership for the department?
That is correct.
Okay. Will you also be checking with the state being the representatives in his delinquency case, to make sure that there's nothing in the delinquency case that would prohibit Bimri and mom from visiting?
Yes.
One moment, Your Honor.
Yes, I think Emery. But you can't have that one because I burnt it. I burnt it.
Last question. Does the department have any objections at this point to, if it is staffed with upper leadership and approved for in-person visits, is there any issues or concerns from the department regarding others being included in those visits, specifically fiance, Mr. Hudson, or sister, things like that?
That would again be something I have to staff with leadership. Concerns wise, I believe safety at the house is key. So that would be one of my concerns to staff with leadership before a decision is made.
Okay, and are you willing to staff that issue with upper leadership?
Yes.
I have no further questions. Thank you, sir.
Attorney Beatty, any questions for Mr. Aramfalami?
Yes, Judge, thank you. Mr. Aramfalami, what was the delay from January 23rd to February 11th in sending the school records?
So I got the case, excuse me. So I got the case transferred to me on the 3rd of February was when it came back into foster care. Mom came down to the office on the 5th. I called East Store Middle School on the 4th of February to kind of like get the school records. Then I was informed it was never enrolled at East Store Middle School. So when Mom came around on the 5th, Mama shared with me she could not enroll him in school at the end of December 2025 just because there was no time to do that, is my understanding. So in January, it was at the RY. So once I got those information, I was able to get in contact with his previous school, which was Salem Middle School, on the, on the 5th of February. I reached out to them. I did not get no response until the 11th of February.
Okay. And is Salem Middle School where he was at when he was at Kids Peace?
No, that was, trying to remember the name, but it wasn't Kids Space.
Okay.
It was a different placement.
Okay. And you said he's currently engaged in individual counseling, is that correct?
That is my understanding, yes.
Okay, and that's a service being provided by his placement?
Yes.
Okay. So do you know the name of that therapist?
Not yet. I only just got that information.
Okay.
I think it was on Friday or something of last week.
Okay. Okay, that's all I have. Thank you, Judge.
Okay. Just a few questions from the court, Mr. Aramfalami. I'm just looking at the case plan. So it's fair to say the school name is not Kids Peace Educational Center. That was a couple placements ago.
That
And I
is
know
correct,
some things
Judge.
probably defaulted back into this case plan. Okay, so right now, do you know the name of the school that he would attend in Muskogee County?
I do not have that in front of me,
Okay,
Judge.
but it's a Muskogee County school versus it being a school that's on site at Safe Haven?
That's correct, Judge.
Okay. And so you've sent the
I don't know why they're talking about Muskogee County when this is a Hall County case. They're in Hall County right now. This is courtroom C.
records to the school in Muskogee County, or was the placement doing that?
I was a placement. I sent it to the placement, and the
Okay.
placement had told me on Friday that they sent it to Muskogee County Schools.
Okay. And you've not been made aware of any additional items that Muskogee County is going to need in order to get him enrolled?
It was the IEP they were particular about, and that was also sent.
Okay. And I don't know if you're familiar with Safe Haven or have had other kids placed there. Do they offer any kind of on-site type visitation for parents, if you know?
No, I don't know, Judge.
Okay. Okay, I think those were all the questions that I had. So any redirect, Ms. Gravett?
No, Your Honor, thank you.
Okay. Any other witnesses or evidence?
No, Judge.
Ms. Dodson, any witnesses or evidence you would like to present?
Just a moment, Your Honor.
Maybe in Muskogee County they don't have a home for these kids. Maybe he's in the home in Hall County because that's the closest one.
Your Honor, absent objection from any counsel, I would just proffer on behalf of Mom.
Any objection?
No, Your Honor.
Okay,
No,
hearing-
Judge.
Your Honor, Mom did just want to clarify, I think Embracing Arms was the last group home replacement that Bimmery was in. She also wanted to clarify that no one from the state in the delinquency matter, whether it be Ms. Green or Ms. Atkins, any kind of attorneys that are on board for that case, have notified or put her on notice that she is not allowed to have contact with Bimmery. In fact, the entire time he's been at Safe Haven, they've had daily phone calls with one another, so she would be she would have heard from someone from the state by now if that wasn't something
I
that
did
was
not
allowed.
order anything, so I'll just clarify that. There was no restriction from the court on the delinquency case.
So she just wanted to offer that clarification as well as just clarification. I think Mr. Aaron Falami clarified it, but it's not that Mom doesn't want Bimmery back. It's just not safe for her at this time. It's not safe for Bimmery at this time. So that's kind of been her position as to the case plan goals and permanency for Bimmery. Thank you, Judge.
Okay, thank you. Ms. Courtney, any witnesses or evidence?
No, Your Honor.
Okay. Ms. Beatty, any witnesses or evidence?
Just a brief guardian ad litem update, Judge. And most of this comes from, I'm so sorry, Ms. Hobson. I was going to say the wrong name and I stopped myself. But Ms. Hobson has been just on this school issue, just so the court is aware, she has been very much on top of trying to ensure that this gets done. And I understand there's an internal delay within the department in getting the case transferred, and now there's further delay in it being, submitted to Muskogee County, and apparently that's typical for them. But I want to echo what Ms. Hobson has stated, and that I think it's crucial that everyone stay on top of Bimmery getting enrolled in school, because I have seen some communication from Ms. Hobson that when he's sort of sitting around at placement and doesn't have anything to do all day, it's a recipe for trouble with Bimmery, and we don't want Bimmery getting in any further trouble. We're doing this to avoid that. So I would just say that my recommendation would, one, be that he get enrolled in school as soon as possible, and that everyone continue to cooperate to ensure that that happens. And two, that the department look at what we need to do for a visitation between Bimmery and Mom. I understand it's a non-reunification case plan, which I do think is appropriate at this time. So they won't be providing Mom any services for that. But if it's a way that we can work Mom getting down there to visit with him, I think that would be great for both of them and for the family. So those would be my updates and recommendations at this time.
Okay.
Thank you.
Thank you. Okay, any other witnesses or evidence from anyone?
I apologize, Your Honor. Can you repeat that?
Just any other witnesses or evidence before I close the evidence portion?
Nothing further, Your Honor. Thank you.
Okay. Then that will close the evidence, and we can move into any closing remarks or requests from the court. And I will share, just if the parties, from the delinquency standpoint, there is no restriction on Bimmery's contact with his mother or other family members. And I do want parties, this is our disposition hearing, so as much as you can today to provide your recommendations for visitation, knowing that we may have some barriers, not knowing exactly what can be offered at the placement, but I've got to come up with some kind of order today. So if you can cover that in your closing, that would be appreciated. So.
Bren, I am sorry, YouTube eats messages. I can't stand it, and there's nothing I can do about it. But you type this long comment in YouTube, oh, this is funny, this is so funny, gone. So you type it again, gone. And you just get frustrated. I know you're frustrated. I get it.
Ms. Gravitt, would you like to reserve?
Yes, please, Judge. Thank you.
Ms. Dodson?
Thank you, Judge. Your Honor, Mom has no qualms with the proposed case plan that's been tendered or submitted by the Department of Family and Children's Services. I will note that it's not a concurrent case plan. It's literally just non-reunification. I do have, and Mom has some concerns with, prior testimony at the last hearing for the emergency motion in terms of the grandfather is just that we're not sure about his living situation. I know the department will follow up with that. But if it's possible, she's excited to hear that there's a possibility that her dad may be able to do guardianship with Bimmery. Again, Mom just wants to reiterate to the court that her position is not that she does not love Bimmery, and I don't think that's an assertion or allegation that's made by anyone, any party in this case. It has just been very difficult with Bimmery in terms of disciplining him and having him living in the home. That being said, we are asking as part of the disposition for visitation, that there not be any prohibitions to their daily phone calls that they've been having, and that if in-person visitations in the community are possible, And that's what we would be asking for. There hasn't been any evidence or issues in terms of the phone calls. I've asked the foster care case manager if he had gotten any negative reports from placement or otherwise, and the overall statement was no. Previously in this case, we didn't have any issues when it came to visitation. It was not until Benry was reunified and living in the home with mom that we started to see some of these issues, and specifically the underlying incident that gave rise to the delinquency action. So that being said, I just don't see any evidence before the court that supervised visits at this time are warranted. Further, that they couldn't have some visitation in the community based on whatever Safe Haven's guidelines are, or their policies or their procedures, Judge. So that's what we would be asking for. And Mom is definitely on board with guardian ad litem's report and recommendation in terms of, as well as I think it's Miss Hobson. Is that what it is? Okay. Ms. Hobson's efforts to get Benry enrolled in the departments as well. She hopes to see that happening for Benry soon. That was something that she was very adamant about when Benry was in her home. She would also be asking that there not be any prohibitions on this time for allowing either her fiance, who historically, Judge, and I think even at the last hearing, uncontested that he views Mr. Hudson as a father figure. So if father can attend the visits or if sister can attend the visits, just having those immediate relatives, grandfather, grandmother, along with mom, I think would be very helpful and encouraging. I understand it's a non-reunification case plan, but I think that that's still a service that the department can offer Benry that would assist and help Benry. So those would be my requests, Your Honor, and that would be my closing for the court today. Thank you, Judge.
Now it sounds like she's calling him Bemry instead of Emery, but maybe I heard wrong.
Ms. Courtney?
Yes, Your Honor. Benry's content with his current placement and he's doing well there. He's interested in pursuing a guardianship with his grandfather if that can be worked out at some point. All he would be asking for at this time is in-person visitation with his mother, and he's fine with any sort of immediate relatives being present as well.
Thank you.
Okay, no.
Ms. Beatty?
You see the girl in the very center with the white sweater hanging off the back of the chair, rocking back and forth. Benry is right to the left of her. Oops, I shouldn't have said right to the left. Benry is to the left of her, which my camera's backwards, so that didn't help.
Thank you, Judge. I had the same sort of, I guess, noticing of errors in the case plan that the court mentioned, so I'm sure the court's addressed that, but just that the education section mentions that he's enrolled in school at Kids Peace, and then that he's not currently in individual therapy. It sounds like we probably got that information after they prepared the case plan. So if that can be updated, I would concur with the proposal as to visitation. I think it sounds like the daily phone contact is a really good thing. And as long as that continues to go smoothly, I think that that's appropriate. And I also think that in-person community visits, whether they're just with mom or with sister and stepdad, I think that would be really good as well, just to sort of be quality time without that pressure of having to discipline or deal with those sorts of issues and sort of let them get back on the right track. Other than that, I don't have any objections to the case plan. I join in Ms. Dodson's concern of what Granddad's testimony was at the last hearing as far as looking at him as a placement option, but if the department is able to vet that and that changes, great. But I'm hopeful once we get these other evaluations back, we'll see if there's additional services for Benry we need to put in place that were previously missed as this case got bounced to different folks. Otherwise, I think it's appropriate for the court to adopt the case plan that Benry remain where he's at, and that visitation be ordered. Thank you.
Okay. Thank you. Ms. Gravitt?
Yes, Your Honor, may I have one moment,
You
please?
may.
Thank you.
Yeah, but was she even in the room the first couple times? Did you notice if she was like in the room? Did you actually tell her to do something while you were dreaming and then expected her to do it? I had a dream last night that I washed my dog and I woke up today and she's dirty. It felt so real though. Now I gotta wash my dog. I don't want to. Notice I didn't say the B word when I told you that story, because if I said it, my dog would run and hide from me for 7 days. Come on, ladies.
Thank you, Your Honor. I appreciate that. The department would ask at this time that the court find the child is in a dependent condition, that it would be contrary to his welfare to return to the home of a parent at this time, that his current placement is appropriate in meeting his needs, and that the court would adopt the non-reunification case plan presented by the department today, and find that it is an appropriate permanency plan given the facts of the case at this time. Your Honor, as to visitation, the department, wants to put
I think that's his sister, who just got up and walked around. I think that's his sister. I don't know, though.
on the record that at this time there are certainly concerns about having ongoing contact given a non-reunification case plan, but the department isn't asking for no visits at this
What?
time. The department
So mom's like, no, I don't want him back in the house. He is too much for me. He's going to hurt me. So they're saying, okay, not even visits. She's calling him every single day, that says. She's calling him every day and talking to him. And they're like, I don't know if that's a good idea if they're not going to reunite. What? Why is that a bad idea? For what reason? Is mom making him worse? Is that what's best for him, that he doesn't have no contact with mom anymore? I don't understand why they had that whole conversation about that. I can understand if they had problems with mom's fiance, which they don't. They have a problem with mom. Mom is sitting by her lawyer at the top on the left of your screen.
its greatest concern is just, these visits are to happen. The child get his hopes up that he may get to go home, and the result of any harm from that. But the department isn't asking for no visits at this time.
That's not what they said, Granny. They didn't say mom is agitating him, which that would be a valid reason. They say he gets his hopes up that he gets to go home, which, I don't know. Oh, the monitor. Is that the guardian ad litem? She sounded like it. She did sound like it. I don't know. I don't know why they would have a problem with visits from mom. I don't, because it sounded like mom's lawyer was asking for, it didn't sound like she did, ask for in-person visits in a public place every once in a while. So mom wants a little bit more contact. She just can't have him living with her.
The department is okay with phone calls. Another concern the department has is just that the supervision piece of the visits, given that it's unconfirmed if placement can do that at this time, the department would just ask the court not order that it be the responsibility of the department to provide supervision for the visits, given the non-reunification case plan. But that is something the department is willing to speak to the placement about and see if that's something they can provide, and even to the extent of inquiring with the placement as to their ability to provide virtual visitation. And the department would ask that should visitation occur in person, that it be the responsibility of the mother to visit the child at his placement, and that she be responsible for transporting herself and arranging that. As to, I guess, going along the lines of the non-reunification case plan, for the court to find, just looking at the code, however the court would deem appropriate to find it. I think as to the father, the putative father in this case, I'm trying to look back at my notes as to some of the history on this case. If there is an aggravated circumstances finding, there is. I've been whispered it is, so I will not ask for that. And I think at this time, looking at the code in 1511, 204 D2, if the court could find that the child has been removed from his home on at least 2 previous occasions and reunification services were made available on those occasions, if that is what the court would like to find. I'm just looking at the code. I know the ground for termination for parental rights exists is also one of the options in the code for the court to find. If the court should be inclined to make that one of those findings, it would be specifically the department would look at D2 if the court would consider that finding. But otherwise, Your Honor, the department would just ask for the court to find that the department has made reasonable efforts and to adopt the non-reunification case plan.
Okay, thank you. Give me 1 second. Okay, we are here today for a disposition hearing, and I will find that I'll just adopt whatever the previous diligent search was, the case plan that was proposed today. I will adopt that case plan, which is a permanency plan of guardianship. Memory, remind me, 14?
Yes.
14, okay. Talk a little more about that in a moment. I will go through the case plan and make changes that I know should be made, and I'll just ask if anyone else reads through it and sees something that they think should be changed too or updated. If you'll let the court know just by the end of the week, I'll give anyone else a chance to respond if they see something that we want to update in the case plan. But ultimately, the case plan goals are appropriate, and we'll adopt the non-reunification case plan, but the permanency plan is guardianship at this time. I will find that Bimry continues to be a dependent child, and it would be contrary to his welfare to return to the home of any parent at this time, and will, as the disposition, grant temporary custody to the Department of Family and Children's Services. And looking at, those are really the statutory findings required for our disposition. And looking at the visitation, this is what I'm going to say based upon just what this court knows historically and the requests that have been made by the parties at this time. I'm going to find that unsupervised phone and video contact between Bimry and his mother can be as frequently as allowed by the placement. I will authorize in-person, either supervised or unsupervised, as can be arranged by the mother with the placement. So I think, Bimry, a lot of this is going to depend on how you're doing at the placement.
That's awesome. So he could get in-person visitations with mom. Good job, Judge.
And the placement's rules and regulations. They may say you have to visit on site with a supervisor. They may say you've earned 2 hours in the community, something like that. I don't know the rules of Safe Haven, but given the department's request, I think we all have some concerns about Bimry's behavior and kind of what led him to returning into foster care, but I'll note that there was lots of visitation and time spent with mom that went well. So as long as Bimry can behave, I think, mom's going to be willing to do that visitation. So I'll just allow it as can be arranged by the mother with the placement and pursuant to whatever the placement allows. So it's just going to be whatever the placement allows. My order will authorize mom, Kenneth Hudson, Gwendolyn Thompson, or Jeffrey Smith, and little sister whose name I don't know. Casey, and can you spell that?
C-A-S-I.
C-A-S-I. Thompson.
Her friend?
Newberry, okay. Casey Newberry to participate again as allowed by the placement. So they might say, just one other person. They might say no other person. But ultimately, these are all individuals who are part of Bimry's life. And since that's going to be a long drive to take, I'll give mom some authority to kind of, arrange if, grandma or grandpa is able to drive down and help take some of that burden. The court will allow that. On the non-reunification, I certainly think in looking at 204, we've got multiple items in 203A, which is allowed there in subsection D, that all apply to the putative father. And I do recall that aggravated circumstances were previously found. If they, I'll renew those findings, and certainly in the 203, we've got aggravated circumstances. They're listed in letter 1, or number 1. One's not a letter. Maybe one day it will be. As to the mother, I'm just going to go under A. She consented to the non-reunification. But
Thank you, Jude. Thank you so much. It's lovely to see you.
Then D, that reunification plan is not appropriate considering the health and safety of the child adjudicated as a dependent child and such child's need for permanence. I can make that finding. The subsection numbers there are just items that there would be a presumption that it's detrimental. I don't think I have to make those findings, so I'm not going to make a finding in the numbers and such as the removal. I mean, this is his second removal to foster care. I'm not aware of a third or one before the one in 2021 that would cause this to be more than at least 2 previous occasions of removal. So that being said, we've got what we need there in D without needing to follow one of the presumptive reasons for non-reunification, and therefore we'll find reunification is in Bemery's best interest at this time for our permanency plan. Now, that being said, the permanency plan is guardianship with the proposed permanent guardian being Jeffrey Smith, and I recall his testimony that he may be willing to serve as the guardian, that housing is an issue for him right now. Bemery's behavior will always be on the table as a potential barrier or not to a guardianship. The reality is if we get down the road when Bemery starts hitting the age of 16 and guardianship is still our proposed plan and Mr. Smith is not willing or able to be that proposed guardian, we're probably going to be looking at what else is out there. Are we looking at shifting it over to an APLA plan, or maybe Bemery's doing some things where mom's willing, able to step up to the table. I'm not going to close any of those doors just because that's not what's in the written document right now. Because I think this is not going to be one that's going to be quickly remedied. And so I think we'll have plenty of opportunities to keep working to find the best outcome for Bemery. Mr. Anfalami, I'm just going to ask within the next 7 days if you will provide the name of whatever the school is that Bemery is supposed to be going to down in Muskogee County, if you'll provide that to the parties so any of the parties can also follow up. I'll just let the parties know if you've not dealt with enrolling a foster child in Muskogee County schools, I do not know how they get away with it. I've had kids sit 30 days or more with Muskogee County just being like, no, well, we'll do it when we feel like it. I don't know the answer to it. I wish I did. I mean, I've yelled at DFACS about it, and I know they've done what they can, but Muskogee County is like a black hole for enrolling kids from foster care. So the old expression is squeaky wheel gets the grease, I think. So, which is why I'm asking Mr. Anfalami if he'll ask the placement, what's the name of the school, and then I'm not telling anybody to harass anybody, but certainly those with legal authority to reach out and say, hey, what's the status? I'll just encourage everyone to be part of that, the grease that's going to that squeaky wheel to try to make sure we can get them re-enrolled as soon as possible. Now I feel like I've just kind of been talking. Is there anything else that I've missed or I need to cover? Oh, reasonable efforts. You've made reasonable efforts.
Thank you.
Anything else?
Your Honor, for clarification.
Yes.
I would just be asking, I meant to ask Mr. Anfalami this earlier, but can we include in the order that mom is allowed to have contact with Safe Haven in terms of facilitating the visitation?
Is there any opposition from DFACS on that end if I've ordered for her to be the one arranging any visitation?
Or making sure at least that mom's listed as a contact with Safe Haven so that she can facilitate those? I anticipate historically we call group homes and I get parents calling me back saying they're not allowed or DFACS doesn't put them on a list or whatever.
Or if you want to still be the middleman for arranging visitation, that's fine too. I'm just trying to alleviate DFACS from.
Same.
And you certainly can provide the court order, and I would suspect somebody would provide the court order since I'm kind of doing this visitation outside of the kind of DFACS's responsibility.
Yes, Your Honor, the department will follow up with the placement, but given they're having phone calls, he's likely already on his call list, but that's something the department will follow up just to confirm with the placement.
And I'll just say, along with the school, if Mr. Anfalami can ask, what's the name of the school and what's the name of the person that the mother should contact to arrange any visitation? And I'll include that in the order that the mother can have direct contact to contact someone from Safe Haven or whatever placement to arrange visitation. But Mr. Anfalami, if you'll provide that specific person, that might help from calling a number and getting some kind of phone directory and then getting lost along the way of extensions.
I think that's all I had, Judge.
Okay, anything else from anyone?
No, Your Honor.
Okay, well, the court will draft the order for today. Next hearing, and because we came back in as a modification of disposition, I don't feel like the code requires us to jump through the hoops of all the first type early reviews, and I would just be inclined to set this out for permanency 6 months out. Is that,
That sounds good. to me.
everybody good with that? Okay. We have permanency already scheduled in June, so why don't we just, is it permanency June? What's the date on it? We're already scheduled for June 5th at 1:30. I see it, well, it was a protective order review. We can make that be permanency if everybody already has that on their calendar.
I do, Judge, and I think I'd put on the record, and there weren't any objections at that time
You
for me to
will
appear
likely be,
remotely
yes.
because I'll be on maternity leave, so that would just be my follow-up request on that.
Okay. Well,
Want to bring the baby?
No, that's negative.
okay.
I'll have the baby on Zoom.
As long as you show the baby on Zoom, I guess we'll allow that. Okay, so we'll just convert that protective order review to our permanency hearing, so that'll be June 5th at 2:30. Okay. Well, then, thank you all so much. I won't circulate another acknowledgement of future hearings notice since that was a date we already have. And I just wish everyone the best. And Bemery, I'm thrilled to hear so far so good, but you just got to keep it up, okay? Okay. Okay, everyone may be excused.
Your Honor.
Thank you, Judge.
Thank you.
So June is far away, guys. Maybe Mom and him will work on it and develop something. I don't know. I think we're going to Francisco. There's 2 judges that have this camera angle in this court. I know one is Francisco, but for the life of me, I can't remember the name of the other guy. So, but I'm going to say we're going to Judge Francisco because no one's going to know the difference.
Borkowski for record date.
Borkowski's cause number is 2510 F5 278. Good morning, Mr. Borkowski.
Good morning, Your Honor.
Set for record date, which is a deadline for entering a plea agreement, and I note that one had been filed in your case. Is that what you want to do today, sir?
Yes, sir.
Mr. Borkowski, we can have you brought over and do this another day, tomorrow even, or we can do it from the jail. It's up to you. It's your right. You have
I
preference?
agree, just go ahead.
Do it today? Okay. All right, then that's what we'll do, sir. We're looking at this document. It is 4 pages long. The 4th page just has signatures on it, and there's a signature line for Timothy Allen Borkowski. Did you sign that document, sir?
Yes, sir.
And when you signed that document, had you gone over it with Mr. Kozlich? Did he explain it to you and answer any questions that you had about your document?
Yes, sir.
All right. When I hold that up, you probably can't see any details at all.
I got off work, I don't know, around 4.5 hours before this stream started. And this was full of the leftover coffee that we had, which really, it was only 4.5 hours ago. I know it was yesterday's coffee, technically, but it wasn't really. I just, and it's gone now. You know what? Biscuits and gravy sounds like a plan for today, because I didn't eat after work. I fell asleep.
Can you?
I can see the black and white.
That's it. Yeah, it does no good for you. Okay, then, Mr. Borkowski, toward that end, please raise your right hand. You promise to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. Your age today, sir?
50.
Are you under the care of a doctor, psychiatrist, or psychologist today?
No, sir.
Are you under the influence of any drugs, narcotics, or alcohol today?
No, sir.
Are you under the influence of any prescription medication that might affect your ability to understand today's proceedings?
No, sir.
The terms of the plea agreement tell me that you agree to plead guilty to count 1, escape, as a level 5 felony, and the state agrees to dismiss all remaining counts at the time of sentencing, correct?
Yeah.
And despite the fact that a level 5,
He escaped. How do people escape? Let's see. Okay, they do call escape if you're out on like work release and you go get a cup of coffee. That's escape. But let's see what this guy did.
is normally punishable by 1 to 6 years of incarceration. The state and you agree that there's going to be a cap of 3 years on any initially ordered executed sentence, correct?
Yeah.
And the significance of that meaning that you're not exposed to up to 6 years on the front end, you're exposed to up to 3 years on the front end. That's the worst thing that could happen to you on the front, not necessarily that it would, but it's the worst, right?
Yes, sir.
So the court can give you more than 3 years of time on the sentence, but anything over 3 would have to be suspended and on probation, correct?
Yeah.
Okay. Further, if you're sentenced to any probation or community corrections term, you'll do mental health and substance abuse assessments and follow through with any recommended treatment. And otherwise, the parties are free to argue as to any term of the sentence not specified above, correct?
Yeah.
And that all pertains to that lead cause, which is the 278 cause number, correct?
Yeah.
Further, when it comes to causes 2408 F6 822 and 71 D05 2504 CM 813, that you agree that by pleading guilty here, you will have admitted to violating your probation in those cause numbers, correct?
Yeah.
And so that 3-year cap wouldn't necessarily apply to those. The worst thing that can happen to you in those cases is that you'd be exposed to any backup time that you had on those cases, correct?
Yeah.
Does that make sense to you, or is that not track for you?
Yeah. I mean, I get it, but I didn't know I was started that probation over there.
You can violate your probation before you even technically start it.
And Mr. Borkowski,
Hang on.
and Mr. Borkowski, this is also that you were serving those sentences at the time. Remember, you had that 3 years executed.
Yeah, it makes sense when you said that, yeah.
Yep.
All right.
Okay, good. I just want to make sure we're all on the same page, sir.
Yeah.
Okay, very good, very good. Let me pull it 270. Okay. So, if you elect to make these admissions also to those probation department or probation violations, you'll be waiving your right to have a hearing where you can contest those allegations, and the state would have to prove those allegations to the court by a preponderance of the evidence. You understand that, Mr. Borkowski?
Yes, sir.
Okay, very good, sir. All right. So, having discussed all the terms of the plea agreement, is that what you want to enter into today, sir?
Yeah.
Okay. You understand that right now the court's not bound by this agreement. I don't have to accept it. I haven't signed off on it or helped negotiate it in any way. I've got 2 options. One is if I accept your guilty plea, I have to sentence you according to these terms because those things are bound together in this contract. My other option is I can reject it all and go back to square one with all pleas of not guilty. Do you understand those 2 options?
Yes, sir.
Now, if you elect to plead guilty, if you didn't elect to plead guilty, you went to trial on count 1, the state would have to use legally admissible evidence.
All right, guys, what do you guess? What do you think? When Brendan says he has that for dinner, does he really mean SpaghettiOs? Is that what he really means? I'm going with yes.
Unanimous jury beyond a reasonable doubt of certain things. And as far as count 1 pertains to, the state would have to prove that you unlawfully, knowingly, or intentionally on or about October 1st of 2025 here in St. Joseph County, state of Indiana, you fled from lawful detention at St. Joseph County Community Corrections, Dukem Center. You understand that that's what the state would have to prove?
Yes, sir.
Now, if you elect to plead guilty, you relieve the state of the burden of having to prove those things because you would admit today that those things are in fact true. You understand that?
Yeah.
And therefore, if you elect to plead guilty, that would be a waiver of your speedy public trial before a judge or a jury, and will proceed right to judgment of conviction and sentencing all without that trial that you're attempting. You understand that?
Yes.
Further, if you elect to plead guilty, that's a waiver of your right to see the evidence and face the witnesses against you at trial, to confront and cross-examine those witnesses, as well as your right to use the court's subpoena power to compel witnesses to come testify on your behalf at your trial. Do you understand those waivers?
Yeah.
Mr. Borkowski, if you elect to plead guilty, you'll be waiving your right to remain silent because at trial you can never be compelled to testify against yourself. But in order to plead guilty, you have to make an admission, which is testifying against yourself. Do you understand that?
Yeah.
And Mr. Borkowski, if you plead guilty to count 1 and ask the court to convict you of count 1 and sentence you according to these terms, and the court does that, you can't go back and appeal your conviction or your sentence. Do you understand that?
Yes, sir.
And if you give up your right to appeal your conviction and sentence, then you're also giving up your right to have a public defender represent you on the appeal that you just waived, correct?
Correct.
So essentially, in order to plead guilty, you're waiving all of your rights except your right to have an attorney working forward with you on this case, correct?
Yes, sir.
Okay. We talked about the possible punishment of a level 5 being 1 to 6 years, but it's also punishable by fines up to $10,000. You understand all those possible ramifications, sir?
Yes, sir.
And you know the felony conviction would prohibit you from possessing firearms, correct?
Yes, sir.
And Mr. Borkowski, do you have prior felony convictions, sir?
Yes, sir.
Okay. And do you have prior misdemeanor records, sir?
Yes, sir.
How about juvenile adjudications for delinquency? Do you have any of those?
No.
Okay. So you understand that your criminal history could act as an aggravating factor at your sentencing hearing, sir?
Yes, sir.
Okay. Mr. Borkowski, were you on parole or probation at the time of this offense?
I guess they know.
Yeah. You were on probation and serving sentences, right?
Yeah.
Okay, so here's what I have to warn you about. If you're on parole, probation, bond, or OR, or if you have any other cases pending, if you get sentences in all these different matters, then those sentences by law probably have to run consecutively, not concurrently. You understand that? For sure, like the time you were on community corrections, that sentence, and this sentence here would have to be run one after the other. They can't be run at the same time by state law, right? Okay. So Mr. Borkowski, you're a U.S. citizen, is that correct?
Yeah.
So with all of your rights in mind and the possible penalties, you still want to enter into this guilty plea?
Yeah.
Do you think, are you doing that because you think this plea agreement is in your best interests?
Yeah.
Did anybody use any threats or force against you to get you to enter into this plea, sir?
No.
Anybody give you or promise you money or anything of value to get you to enter into this plea?
No.
Anybody make you any promises aside from those contained within your plea agreement that were used to induce you to take this plea, sir?
No, sir.
And are you happy with the work that Mr. Kozlowski's done on your behalf, sir?
Yeah.
All right. Thank you, Mr. Borkowski. Mr. Kozlowski, factual basis, please.
Thank you, Your Honor. On October 1st of 2025, you were here in St. Joseph County, State of Indiana, correct?
Yeah.
All right, and you had been placed with the Dukem Center on a work release placement, correct?
You do.
Yeah.
And you went on the transport from the Dukem Center to Memorial Hospital, right?
That's what they were calling it.
Right. And at the time, you were waiting, kind of for your turn, and you ended up leaving Memorial Hospital and leaving to go get some cigarettes and some other things at a convenience store, right?
Yeah.
All right. And you understand that when you're at Dukem Center, you understand now that when you're at Dukem Center, you can't leave any type of trip or anything like that without their permission, right?
I don't know.
Right. And so you weren't staying in the place that they told you to stay. So you understand that means you left lawful confinement, correct? Right. No further questions, Your Honor.
Any issues on that one, State?
No, Your Honor.
Okay, then
Okay, so he went to the hospital, and then he left the hospital to go get a pack of cigarettes, and then he came back. So they're getting him with escape. Let's see how much time he gets because of this one little 5-minute trip. But you do eat canned, Bren. I know you eat canned because you told me that you order every day. You order the food to come to your house every day. And guess what? Kitchens use canned. They open it, they open the can, and they heat it up. And then they charge you $16 for it.
violation, sir?
You understand that by admitting to these new criminal offenses, you're also admitting to violating the terms of your sentences in that misdemeanor case and that F6 case, correct?
Yeah.
All right. No further questions, Your Honor.
Stay satisfied with those.
Yes, Your Honor.
Okay. Well, Mr. Borkowski, based on our conversation and your admissions just now, I find that you do understand your rights and the possible penalties and nature of the terms that you pled to, that you knowingly and voluntarily waive your rights in order to enter this plea agreement, and that a factual basis exists when you're guilty of the new charge plus the 2 violations. We have a right to be sentenced within 30 days, which brings us to March 18th.
That works, Your Honor.
All right. And we'll order a pre-sentence investigation in this lead case, the 278, and updated PSIs at 822 and 813. to make sure that we get all the correct credit time for you, okay, in all those cases.
I don't know, Bren. I worked in a lot of kitchens, and I just can't imagine that you guys don't have canned. I mean, it would be impossible for my brain to get there, because I mean, we have a lot of canned food. I don't eat a lot of canned food, not in the house. I don't like maybe corn. I do eat a lot of corn out of the can, but in a kitchen, everything is in. You have to buy in huge bulk for a restaurant, and they use a lot of cans, a lot.
And then we'll proceed to sentencing on 318. Any questions, Mr. Borkowski?
So are you keeping me?
He wants to address his bond in this.
Okay, go ahead.
We acknowledge that he's not entitled to bond in this case, as he is pending, or he has a sentence that he is currently serving out of that community corrections case that we just talked about.
Right.
However, he has served a considerable amount of time in, and as the court heard in the factual basis, you know, this is not great, and it's never good to have a failure to return or leaving lawful detention charge. However, this one is, I think, slightly different. He was not in the wind for weeks. He was in the wind for minutes as he walked away from the hospital. Allowing my client to get out and try to get some services in place for a potential sentence, I think would be beneficial to him and to get him out and reoriented to what's going on. Again, he has been in custody continuously since the beginning of October on this matter. He's still got some time left to go on those sentences, but we would ask that he be released on a reasonable bond as the court sees fit. And we would also ask for a Michiana Community Corrections assessment. I neglected to ask for that earlier, Your Honor.
I didn't ask, so. All right, we'll order the evaluation from MCC to see if they're eligible for their programming. I think maybe you and the Newcomb Center have broken up with each other. So we'll let that relationship go. Yeah, okay. So here's the thing. When I consider that request, if I had somewhere else to send you as opposed to jail, if there was a middle ground, like, community corrections or something like that, between jail and absolute freedom, I'd consider it. But right now, those are my two options, and I'm going to elect to hold you until March 18th. Okay, sir? We'll see where we're headed on that. Thank you. Thank you.
Yo, he left for 5 minutes, and he's not getting out. He has to stay in jail now until they get to his for 5 more days at least. Now this was back February 25th or whatever, but he's been in jail from October for this escape. October till March 18th. He's stuck in jail because he left for 5 minutes. Don't escape. Don't escape when you're in jail, guys. This might get a little lawyery, but it's only 9 minutes long. I thought it was interesting. It's a motion to exclude.
Okay, I think I'm just down to you guys. All right. Let's do it. State of Indiana versus Wadley Labossiere, maybe? 49 D17 2510 F6 032 832. I do have the state here by Connor Henderson.
I am also highly offended they call that ravioli. I am. I feel like we should all write a letter and sign it and say you can't call that stuff that's in a can. You're not allowed to call that ravioli. That's not fair. You have to pick a different name, like raviola or raviolo. That's fine. You can make it close to ravioli if that's what's in your heart. But you can't call that ravioli. Ravioli is so good. It's so delicious. And yeah, that stuff is fine. If you're hungry, you just pop open a can and it's nice and filling and you're good to go. But that's not ravioli. Oh.
Ms. Ciarich is here on behalf of the defendant. I think you were, Ms. Arch, you were going over the offer with the defendant back when we were here earlier in February. So how'd that go?
So Judge, what we're doing now is translating his tape statement with the police. So he gave a statement while in custody through an interpreter. So our interpreter is translating that into English. There may be a language issue. So we're doing that. That should be ready in about 10 days. And then also just a minute ago, I just filed a motion to release my client's cell phone from property room because he believes that he has exculpatory evidence saved on that cell phone.
Does the state have an objection to the release of the phone?
Yeah, we would object to this, Judge. The case was filed back in October, and that exculpatory evidence was on his phone since October, and now they're moving to have his phone released in February, 4 months later. Yeah, we
Dude, your argument just made you look stupid. You've had his cell phone since October. You've had plenty of time to get any information off that phone that you need. Give him his damn phone back.
would object for that reason.
Judge, I got this case like 2 weeks ago, and yeah, I think exculpatory evidence. There's no reason not to release a cell phone.
Is there any reason to keep the cell phone? Why are we keeping this? Why do you know what I mean? Forget them and what they want. What about just releasing the phone? I mean, does the state have a use for the phone? I could say back to you. I mean, you've had it for 4 months. Wouldn't you know whether you need? I mean, you maybe not. I don't know.
I have no purpose for it, Judge.
When I see it, I don't know if you just filed it 10 minutes ago, it might not even be in my queue, and I'm not going to look right now, but I'll grant your motion to release the cell phone. And then, what are you translating? What's getting translated?
So my client was taken into custody. My client speaks Haitian Creole. He was taken into custody, and then they couldn't find Haitian Creole interpreters. So he said, okay, I speak Spanish too. So then an officer who speaks limited Spanish spoke to a person who spoke limited Spanish, and that's their custodial interview of my client. So we want to see who, if anybody understood anybody, what was going on here. So I need to be able to read it or hear it in English.
All right, so what you're asking me for another remote attorneys only after 10 days, and to give you time also to look at it and all that, correct?
Yes, Judge, and I also need to know if prosecutor's available for a tape statement. I believe I emailed you, Mr. Is your last name Henderson? Henderson, sorry. And are you available first week of March for a deposition?
Yeah.
Of Maria?
Later.
Can you email me?
I can email you, yes.
Okay, thank you. So that's it. We just need a cell phone, we need this transcript, and we need a tape statement. So we'll schedule that hopefully today.
March 18th at 8:30 for remote attorneys only.
Thank you.
So they did an interview with this guy.
6472.
They did an interview with this guy with someone who didn't even speak his language. Come on, guys, do better.
I do have the state here by Connor Henderson. I have Ms. Wickert here on behalf of the defendant. I think there was a tape statement on February 10th, but there was also a motion to exclude under the case ending in 026472. There's a pending motion to exclude the testimony of Teresa Jackson. Maybe, was that granted already? Or just, I wrote down that it's, no, that's been granted. Teresa Jackson's been granted. So then you did the tape statement of Ebony Smith. And then did I get, after I looked at this, I think maybe in my queue, I have a motion to
Yep.
exclude Ebony Smith. Does that make sense?
That was filed yesterday.
Yeah. And then I thought yesterday, maybe during our negotiations, we'd talk about it, but it was too crazy. And so we're doing it today. So state, you don't have Teresa Jackson. I don't think you got Ebony Smith either.
That's correct, Judge. Attempts were made to contact Ebony Smith. She told me that she was not going to participate in no short order. And so I would ask that you take the motion to exclude under advisement and set this for a show cause hearing. And give Ms. Smith an opportunity to explain for herself why she did not appear after receiving a subpoena. Depending on that, we can then have a hearing on whether Ms. Smith should be deemed unavailable. I
guess
believe
what I'd say in response is you don't have the alleged victim on this either. She was a witness, and do I think people should respond to subpoena? Of course I do. But I'm going to grant the defense's motion to exclude the testimony of Ebony Smith. So where does that leave the state?
That leaves the state to
Judge, I believe
dismiss
that's
the
going to be
case.
dispositive on
Yep.
this one, and a written dismissal will follow. I'm moving to dismiss now, and I will file a written motion later today.
And I'll grant your motion to dismiss. All right, and then let me look at where that leaves us on the probation violation. Hold on a minute.
My stomach is not growling at me. I should be, but it's not. I'm going back to bed in a few minutes. Then I'll think about it.
All right, so that's going to be, so I don't know, who do I have? Tommy or Sarah, who's ever doing this one, make sure the no contact orders, there's 2 of them, get vacated. And then also he's got to be released. I think he's on community corrections GPS. So we need all that done.
Is that on
He's gotta-
is that on the 472 number?
That's on 472.
Okay.
Okay. Now on that probation, I'm not moving. Here we go. Come on. Let me move this. I'm gonna move this to. The court staff. Okay. People, I didn't write that down.
I think we're just waiting for her to give another date, and we don't need. Consequences. Let's hear some consequences. I love
They
Judge
received the
Thorne.
money for it. I mean, they took the money out of my bank account. They said they were gonna show up at court today, but obviously they didn't.
All right, so you were here a month ago.
Yes, sir.
And at that time, attorney moves for 1 week continuance, get defendant compliant with help of a friend. 30-day continuance granted, defendant to be compliant with track watch or bond to be revoked. Track watch term be continued through probation if necessary. Reset to today. So what happened since last month?
Well, they kept on putting me off about the track watch. I mean, I paid the money. The people that run that system, I don't know who they are. I mean, I had the manager, I'm pretty illiterate on the computers. I had the manager of the park, run the system, and I mean, I paid the money out of my credit card. They had the money, they got the money.
When was that payment made?
I don't know, a couple weeks ago. I mean, the money's been paid to them.
Between now and the last time you were in court?
Yeah.
Okay.
It's been.
So since you were here last, you paid for it. How much did you pay?
I don't remember. I'd have to look at my statement in the bank. I don't remember how much it was. I really don't.
And how did you make the payment?
Through my credit card.
To whom did you make the payment?
I can't remember the name of the company. I don't have the bill with me.
Ms. Matu, can you shed any light on this?
Solutions reported that they received calls from Mr. Lloyd and regarding the enrollment, that they went over the rules and the process to enroll. They tried to explain to him everything, but it seems like he wasn't understanding. So they requested a teacher ID, a photo of the front and back of his credit, so debit card, and a full proof of address. But they are not sure that he's understanding what is being explained to him. So I don't see anything about payments because they are requesting for a credit to debit card.
Councilman Brooks, please. Well, Mr. Hendershot, I made you a promise a month ago. That if you didn't get this done, I was going to revoke your bond. Didn't get done, I'm revoking your bond. You're going to be remanded to the custody of LaPorte County Jail. When would you like this reset, Council?
We can reset this early, you say your honor.
Very well.
It'll be March 10th at 8:30.
Hopefully we can get this thing done.
Imagine that.
What?
Judge tells you to get something done in 30 days, and then you don't get something done in 30 days. Oh, he doesn't stream. Oh, Josh, why would you do that to me? He is outstandingly good looking. Yes, I would love to get him every day, but he doesn't stream. Maybe we should all write a letter and ask him to stream at some way, shape, or form. I mean, we could watch him on 11 Alive, but I can't show 11 Alive. Oops. Sorry, there was a comment on Twitch, and I got rid of it, and then I got rid of Twitch because I'm stupid. There we go. That hurt my feelings. All right, now I need to go find another handsome judge to replace him, but that's going to be hard to do. I'm telling you, that judge is very, very good looking. And he's from Georgia, and they stream in Georgia. Why doesn't Carol stream? Why? What's wrong with Carol that we can't see what's going on there? Conspiracy theory incoming. Okay, Josh asked me in chat if I could get Judge Hightower in Carroll County, Georgia. So I looked to see if I could get him, and I accidentally saw pictures. Wow. Then I found out we cannot get him. Oh well. I have more, Drunken. Do not worry. I get every single minute of every single docket he has now. I never ever miss him because I love it. I love it when lawyers get almost arrested. I love it more when they actually get arrested. But yeah. Guardian ad litem judges. See what I did there, Bobby? No, you don't, but you will in a few minutes. And you'll say, oh, no, that's not what I meant. That was rude. I'm sorry, Bobby. I didn't mean that. It was a joke, all right? I didn't mean that. Of course you got it. All right, guys. I'm gonna try to see if I can find an interesting Australian sentencing for tomorrow, shorter than 40 minutes though, and some Judge Fleischer if I can, and a couple of good clips. It's just that I have so much to show you, and I only have a little bit of time, and it's starting to stack up. See, we're still in February, but I do also want to see another Australian sentencing, and then I will see you all. What is today? Friday. Today's Friday, guys. Remember, if you get arrested today, it's possible you don't see a judge until Monday. If you get arrested today, I do not have bail money, but I do have cigarettes that you can use as cash in jail. You just have to tape them on those big roaches that are in your cell. Tape a cigarette on there, and it'll go to the right person magically. Thanks, guys. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss any see